Well, welcome back. I think it's been a week. It's been a week.
Something like that.
You've got to love the new haircut. You've got to love your new haircut. Look, before we kick off, can I just say, and Lewis is going to give me a hard time about this, the app the government's put out, please sign up to it. Please encourage all your employees to sign up to it. You can't make them, but please encourage them. I don't know about you, but I'm getting a little weary of all this. Let's get it over with. And the more people who are on that app, the better. And I know, given my views about civil liberties, you're shocked I've done that. But that's how frustrated I am. So please encourage everybody to sign up to the app. Now, look, today's an unusual format. We got so many questions last time we said we'd run a Q&A session. To be fair to us, I think, Lewis, the first 4 or 5 questions are pre-ordered. And after that, they're going to get fed through to us live. So if you've got questions, please send them through. If at any stage today we feel we've already answered a question, we might sort of say, look, we've answered that, and we'll see how we go. And if we can, we'll try and get through, 40, 50 questions if we can do that. But first, there's been a bit of an update. Treasurer Josh Frydenberg a few days ago said he's refined some things, Lewis.
Yes. Yep.
Now, importantly, understand this, that the technical legal rules that give effect to this have not come out. So we'll talk about one in all in, not on this slide, but I think that's the very first question. I'll talk about it then. But the technical rules haven't been drafted and published yet, as far as we're aware. But Lewis, importantly, some clarifications around shelf companies and full-time students.
Yeah, so the Treasurer has announced that the way that the JobKeeper payments will operate have been changed, particularly for children or for individuals under the age of 18. I don't know, if you're 16 or 17, you might not consider yourself a child. But there was a lot of concern initially that there would be casual employees in particular, age 16, age 17.
Living at home.
Who live at home, who are effectively earning a couple of $100s a week. All of a sudden, for the employer to qualify for JobKeeper, they would have to bump those employees' salaries or wages up to $750 a week. And so all of a sudden you'd have these cashed up school students effectively running around with a lot more money than they'd ever seen in their lives. So to deal with that, the Treasurer has announced that for under 18s, those types of employees will only be eligible to participate in the JobKeeper scheme if they are either not financially dependent. Sorry, I think I got that wrong way around.
Financially.
If they're financially independent, they can participate in the scheme. Or if they're not at school, they can participate in the scheme. But generally, if you've got the typical school student who's still living at home, they will no longer be able to participate in JobKeeper if they're under the age of 18. So that's the first announcement. The second announcement is that the Treasury also worked out that a lot of employers, even small business employers, might have different companies. One company might be the trading company that actually collects the revenue, that provides a service to the public, but they might employ their staff through a different company or a shelf company.
What unions describe as an internal labour hire company almost.
Well, yeah, something like that, or a shelf company that, for whatever reason, whether it's tax purposes or other reasons, the employer has employed people through a separate entity. There was a huge level of concern that those entities might not qualify for JobKeeper because they aren't the entities that are suffering the revenue reduction. The Treasurer's announced that the operation of JobKeeper will be extended to those types of businesses. But with both changes, as Nigel mentioned, the rules are yet to come out, so we will only see the detail in the next day or two.
And let's go to questions. Now, before, I'm going to break protocol now because our very good friend Paul Mondo has texted me and said, can you ask this question before you ask every other one? There's been some changes that just got announced, Lewis, in relation to the first couple of payments and when they're due. And can you just take us through that? Because that's really important.
Yeah, so by way of background, the people watching may recall, if you've seen any other webcasts, that in order to qualify for JobKeeper, one of the critical elements, and this is really important throughout the next 4 or 5 months that the payment's going to be in operation, in order to qualify, you need to pay your employees $1,500 per fortnight in the actual fortnight that you're claiming for. You can't retrospectively pay the employees $1,500 per fortnight. It's different if you're paying someone on a pay cycle that's more than the fortnight, like a monthly pay cycle. There's an ability to reasonably reallocate the payments over that cycle. But generally speaking, for anyone paid weekly or fortnightly, the $1,500 needs to be paid in that fortnight. Now, what the ATO has realised is people haven't started paying yet, particularly for the first 2 fortnights. That is basically the month of April. And so what the ATO has said is for the first 2 fortnights only, so basically for the first 4 weeks in April, you can pay employees $1,500 a fortnight up to the 8th of May.
So retrospectively, in a sense.
Yes, that's right. If you haven't paid by 8th of May, you cannot claim for the fortnights in April. But importantly, the other thing to bear in mind is you need to start paying, if you want to claim JobKeeper in May, you need to start paying in the May fortnights that are coming up as well. So very important to bear that in mind. But yes, there is an extended grace period. You can get your house in order and pay retrospectively by 8 May.
Brilliant. And I think it's going to help a lot of people. Excellent. Well, hopefully Paul's happy with the answer.
Yes, yeah.
Let's crack on. Okay, tell me about one in, all in. So look, very simply, one in, all in is this proposal. You as the employer, you as the business, you qualify, so you've met the 30% hurdle, or if you're a charity, the 15% hurdle. If you're a massive $1 billion plus revenue, you've met the 50% hurdle. So you as the company qualify. The question then is, I have to send out a request to eligible employees to sign up so they get the money. The issue was simply this: can I select who I invite, or do I have to invite all potentially eligible employees? The government said very clearly, you can't selectively invite your employees to participate. Anybody who is eligible to participate has got to be invited. And that's the one in, all in rule.
Yeah, and if you don't, once they're invited, the employee then gets the opportunity to nominate. And what the Treasury has been saying, and yet we do still need to see the rules, is if you don't nominate through the ATO portal all of those eligible employees, you will not be able to claim JobKeeper for any employees. And so that's quite a significant issue that could really disentitle you to JobKeeper if you don't capture all your eligible employees. Again, we'll have to see exactly how this works in the rules. The reality is the rules, we've been told they're being changed for the last 2 weeks. They still haven't been changed.
Yeah.
That says to me that they've worked out there is a fair bit of devil in the detail, and so we will need to see what they say, but need to be very careful. If you haven't claimed for everyone who's eligible, you may not be entitled to payments for anyone.
So I'd probably suggest most people err on the side of generosity, if particularly around the casual question, if there's any anxiety. But that's essentially one in, all in. Can you work extra hours? Here I go. Okay, look, the Prime Minister is both correct and potentially incorrect. Don't ever quote me in front of the Prime Minister on that. You can't compel, let's say a casual normally works a certain number of hours and earns $350 a week. You can't force them, because of JobKeeper, to now work additional hours up to the $750, but the normal process of requesting additional hours would apply. Do you want to add something, Lewis?
It's really going to depend on the employee as well. So if you've got part-time or full-time employees, you could look at the industrial instruments applicable, and they will dictate whether you can give them extra hours or not. Some industrial instruments may entitle you to provide some additional hours of work. Certainly, there's provisions in the Fair Work Act about what is reasonable and unreasonable overtime. But at the end of the day, JobKeeper does not give you any new entitlement to up someone's hours to the equivalent of $750. It's the existing regulatory regime that applies. So if you can up someone's hours now, before JobKeeper kicked in, then you could still do it. But if you need consent, then consent would still be required.
And I bet we'll get quite a few versions of this question, but we'll wait and see. Look at that, we got the same question straight away. So Lou, let's just think about this. We've got a casual, they normally say work 3 shifts a week in my shop. I'm now trying to get them to work 5 to try and take up some slack of that JobKeeper, and they're declining to work.
Yeah, so this is slightly different in the sense that we're now talking about a casual who usually may have worked potentially, but now saying I don't want to work. If that's the case, the starting point, as uncomfortable as this may be to hear, is if they are eligible employees. That is, they're casuals that have been with you for 12 months of regular and systematic engagements. They are eligible employees, and you must claim a $1,500 subsidy for them, and you must pay them $1,500 a fortnight in order to qualify for JobKeeper. There's really a broader discussion that arises if you have casuals that are saying they're not going to come into work. Because as an employer, if you have a casual who over a week or a fortnight or then say 2 or 3 weeks in a row starts saying, no, I'm not coming into work.
I'm declining shifts.
At some point you're going to say, well, obviously this casual really doesn't want to work here anymore, the hours aren't working for them, and you might effectively take them off your books. Now that is still something that you can do. The usual principles apply. So there's unfair dismissal laws that lightly protect them. And so the question's going to arise, well, really, was there a valid reason for letting the casual go? But if over a relatively consistent pattern, that casual is declining work, and you ultimately decide, well, obviously there's no real basis to keep them on because they're not able to do the hours, well, that could form a valid reason for dismissal. And I suspect the Fair Work Commission is going to be very empathetic to any employer who finds themselves in a situation where casuals are not working intentionally, not doing their usual hours that they used to, but still entitled to and claiming the $1,500.
Yeah, I'm with you. I think if the Fair Work Commission before said, look, the bar for the casual answers here, I suspect it's going to say, well, the bar for the casual answers here going forward, it's going to have a very good explanation as to why you're declining work when so many people are actually struggling for work or for hours of work.
That's right. And certainly you shouldn't leap at this in the first week, and I wouldn't leap it in the second. I would ensure that there is a pattern of offering over a number of weeks and refusal over, say, at least 3 or 4 weeks. And at that point, you'd say, look, it really doesn't look like these working arrangements work for you anymore. You're not capable of performing work. And at that point, you'd talk about a separation.
Good. Oh, this is a sticky question. I'll start. You can jump in. It's all right. Look, I'm going to assume in relation to whoever asked this question that when you say staff have already signed agreements to reduce hours or day, I'm presuming there that in a proper way they've contractually agreed to change their hours and their days so that they now contractually have new hours and days. And I'm assuming as well that that contractual agreement wasn't conditional. It didn't say, well, subject to this or subject to that. If that's the case then, Lou, I'm happy for you to correct me if you think I'm wrong, those would be their actual hours and days contractually. Yeah. And if they're the ones that applied pre-JobKeeper, they're the ones that things are going to accrue on. Now, again, I'm assuming that you've done that in a very contractually correct way.
Yep, agreed.
Okay.
So we've got a request here to go over the stand down and leave direction provisions again.
I'll tell you, we'll do this together, all right? So I'll start, and then I'm going to hand over. So I'll do non-JobKeeper, and I'll get you to do JobKeeper. So I think when we met last week, was it last week we were together?
A couple of weeks
ago. I think we said, think about this as like a smorgasbord of options. So I've got stand-down provisions in the Fair Work Act. I've got the ability to give various directions for annual leave in the Fair Work Act. They are still applicable. I've then got some potential provisions in modern awards. They are still applicable. I've then got a world which I'm living in, which is if I'm eligible for JobKeeper, employees signed up, I've got those new JobKeeper directions I can give. They don't kill, one doesn't kill the other, and so they're still available. So, you can pick and choose. And just quickly, Lou, just go back over the JobKeeper stand-down provision.
So if we're talking about standing someone down under the JobKeeper legislation, then there's a number of requirements you need to meet. The first is that they cannot usefully be employed for the period that you're standing them down. So if you're reducing their hours or if you're completely removing their hours, you need to establish they can't usefully be employed for those hours.
We talked about that 2 weeks ago about you don't have to manufacture work for them. The work's got to be genuinely productive work.
Yeah, that's right. Some net gain is associated with the work. So that's the first requirement. The next requirement is the employer needs to be eligible for JobKeeper and the employee needs to be entitled to JobKeeper payments. So what that really means is you need to have cleaned up and satisfied yourself that there's an ability to qualify for the scheme and that the employees are the type of eligible employees that qualify, they've given nomination forms, and they've been notified to the ATO. So you need to satisfy all of those kind of qualification requirements, if we call them that. You then need to establish that you pay them the right amount of money that's owed during the week. So, and there's 3 tests that are accumulated in that. You need to give them at least $1,500 a fortnight. You need to ensure they're getting the right hourly wage. If they're going to work more than $1,500 a fortnight.
So if they're partially stood down.
They're partially stood down. You need to ensure the employer's getting the hourly rate of pay that would usually be associated with that work. Now, if you meet all of those requirements, then you are able to issue a direction to stand someone down. And that's what everyone's going to have to look to effectively trigger in the coming
And
period.
what we've been saying to clients generally is we take that smorgasbord approach, go, well, what are my rights under the Act? What are my rights under an award or an enterprise agreement? In some of our clients' cases, what are my rights under a contract of employment? And then if I am eligible for JobKeeper, what are my rights under JobKeeper? And what's the best mix and match that I might apply to keep employees in my business, keep them paid, but also keep my business running? So it's that smorgasbord approach which we'd recommend. I'm having fun, this is good. Let me have, can I start?
Yes.
Okay.
You seem to say that every question, so don't ask.
He's going to take over in a minute, I promise. Will redundancies require more scrutiny during the pandemic? Probably not. I don't think so. In fact, if anything, I would have thought it might have almost been the other way. There's a general acceptance at the moment in the community that most industries are impacted, most employers are impacted. So there's a general acceptance that there are going to be some job losses, however regrettable. So I don't think so. In relation to the second question, the real issue is at the point where you make that decision to affect the redundancy, are you in a situation where you don't require anybody to do that job? That's the test that you have to apply at that point in time. If the fact happens to be the case, well, if you hold on for 6 months, it might have been a different argument. That's not going to cause any anxiety whatsoever. So it's really the test at the time. I think there's a broader question, which is a commercial question. Some might even say a slightly ethical question, which is if you know that you could hang on for, say, 4 or 5 weeks, from a commercial perspective or from an ethical perspective, should you? Look, that's a values judgment, not a legal judgment. You can make your own values judgment, but it's not a legal judgment.
Agree.
Yeah. I'm going to let you answer this.
So if an employer's on paid annual leave, do they still get the payment on top of the leave already paid? The reality is if an employee's on annual leave, the employer will be entitled to reimbursement for the monies they have paid out, because all the employer's required to do is pay $1,500 a fortnight. Provided that is being paid, whether it's in wages for work or annual leave, the employer is entitled to that reimbursement. But that money doesn't go to the employee. So the employee will get their annual leave, but they don't get some other payment on top. And I think there's a bit of confusion here about this. The reality is that JobKeeper is not a payment to the employee. JobKeeper is a subsidy or a reimbursement to the employer. So this notion that you get your leave and a top-up doesn't apply once you understand that JobKeeper is just reimbursing the employer for money's already paid. So I think that's that one.
Yeah, and look, people will make their own commercial decision on this, and this might sound a little cynical, but if you've got a very large balance sheet provision for your annual leave, you could be directing people onto annual leave. You could be accessing that balance sheet provision. That's not necessarily cash flow helpful, but it's certainly, in terms of protecting your profit and loss, that's certainly helpful. And then you're pocketing the $750 a week, $1,500. That might put you in a much better financial position. So you need to think about that. But yeah, the answer is the one Lewis gave.
So we'll start reading out.
So
Can you please clarify?
We've just been asked to read the questions out. Apparently some people can't
That's
see
right.
it very well.
So
Off you go.
Can you please clarify JobKeeper for staff on unpaid mat leave, and also whether staff become eligible when their government paid parental leave expires, say in mid-June?
That's got to be your question, hasn't it?
So short answer, and this isn't just about unpaid mat leave, there's a lot of questions that we've had about this. If someone is eligible because they're a permanent employee or they've been a casual with regular engagements for 12 months, they are eligible, and once the one in all in rule kicks in, you must apply for JobKeeper for that employee to claim for everyone. What that means is if someone is on unpaid mat leave, they do get access to the JobKeeper payments. You must pay them $1,500 a fortnight. And I mean, what you'll see is a windfall gain to that person because they probably weren't anticipating getting paid during unpaid maternity leave, but that will apply. The only time they are not entitled to JobKeeper payments is when they are on government paid parental leave. When they're on government paid parental leave, you cannot claim JobKeeper payments for that employee, but obviously they're getting paid parental leave anyway.
Yeah, that's the government's desire, so you don't double dip into the government purse.
Yep.
Yeah. We might come, I bet there'll be a question on sick leave. We might come to the sick leave stand down issue later on if we can. Yeah.
Casual employees, if there's not going to be ongoing work on the other side, should this casual be included in the JobKeeper payment? ATO states that there is an expectation of ongoing work to be eligible for the JobKeeper payment.
Well, he's looked at me for a reason, I suspect. Yeah, I don't want to be seen to publicly disagree with the ATO, but the legislation doesn't use any reference to ongoing employment. In terms of casual employees, it's 12 months service, and it's regular and systematic test applies. And as long as you've also been engaged as of 1 March 2020, then you're across the line. So it might be the case that the ATO is saying that, but it's not actually in the legislation.
Yeah, and that means that it's up to the employer at what point they might let the employee go or not. But it's really a matter for you. But just remember, with one in, all in, if they do qualify, you need to claim for everyone. That's on your books.
Yeah, even if in 3 weeks' time there's no work for them and it's a different issue. But yeah, and the presumption here, I think, would be unless they were being terminated for performance issues, such as we said earlier, declining to work shifts or whatever, the presumption would be you'd most likely just stand them down.
If I bring back stood-down employees in New South Wales to work for the JobKeeper payment, could I stand them down again if the subsidy ceases? And would super then be payable on the $750?
Well, I'll take one. I'll give two to you if you like. So look, the answer to the first question is effectively yes. So you bring them back, you start paying them JobKeeper. You might partially be standing them down under JobKeeper when you bring them back, depending on their circumstances. Let's say that JobKeeper ends. When's the current date?
30 September is the currently announced date.
Let's say that things sadly haven't got any better. We get to 30 September, the scheme ends. You've then got your general rights about stand down still operating in the Act, potentially if you have an enterprise agreement, or if you've got stand down provisions in an employment contract, you've got those. So you could have a situation where you've stood down under the Act, you bring people back, you pay them JobKeeper, JobKeeper comes to an end, things haven't got better, you have a right again under the Act to stand them down, enterprise agreement, contract of employment, and you stand them down again. Now, gosh, I hope we don't get to that. That would be a pretty terrible world to be in. But yes, technically you could do that. Super.
Super, so there is a little bit of confusion about how super operates with JobKeeper payments. The reality is for every ordinary hour that someone works for you, you have to pay superannuation. And that is not included in the $750 per week or $1,500 a fortnight. So if someone does 20 ordinary hours of work in a week, you need to pay super on those 20 ordinary hours. And you can't claim the super as part of your $1,500 you're paying them a fortnight. But if you have someone who is stood down and is nevertheless receiving JobKeeper payments, you do not have to pay super on those payments because they're not working ordinary hours. And for anyone who's familiar with super legislation will know, super, the obligations all stem from one key consideration, and that is, are they ordinary time earnings? And ordinary time earnings is what super's payable on, and you can only have an ordinary time earning if it's an ordinary hour of work. So it's a very simple rule. If they're working hours for you, super is payable on every hour worked. If you're just paying them JobKeeper but they're not working, no super's payable on those JobKeeper payments. And I'm pleased to say to the other listeners that our answers in respect of this slide apply across the country, not just to New South Wales, notwithstanding their obviously New South Wales-centric focus.
Yeah, absolutely. Yeah, Australia-wide.
Any experiences of employees largely unaffected by a downturn refusing to agree to be enrolled for JobKeeper because they fear it gives the employer too much power?
He's looking at me, so I think I got the question. Look, I'll be frank. No, we haven't. We've got a lot of clients who actually aren't affected by what's going on, and they're doing very, very well. We've got quite a few clients who are actually aggressively trying to get hold of JobKeeper to keep themselves going. I'm not aware at the moment of an employee declining where the offer's been made. I know of situations where somebody might historically have worked for maybe two or three employers and has picked the one they think's the best bet in terms of not just, perhaps they've made a decision based on, oh, I think you're going to look after me the most, so I'll go with you. So I've seen that, but I haven't seen anybody go, I don't want to agree to this, and in doing that, I'm avoiding giving you the right to give me, say, JobKeeper direction. So I haven't seen that at all at this stage. Most of the unions that I'm talking to are telling their members to sign the form. They're saying, look, get the money, get it across the line, help out your employer, because at the moment, some money's better in some cases than no money. So most unions are actually being very supportive at the moment. You haven't seen anything, have you?
No, I think it's more the other way around is what I've seen. I've seen employers that are hesitant to apply for JobKeeper, particularly because of concerns about the one in all in rule, that they're saying, well, if I'm going to have to start making payments to all these casual employees that I've already stood down, there's a huge impost on my cash flow. We've heard of waiting periods with some of the banks of quite significant periods of time to get monies advanced, to pay that out. And that's where the reluctance has been. The main reluctance for participation has been on the employer side, really arising from a reluctance to put that strain on their cash flow to pay in advance.
Which is why that 8 May retrospective rule, I think, has come in, probably to help out with that.
A full-time employee on common law contract can still working. Monthly gross wages of $9,000 has been asked to take. Has been asked to take a 15% pay cut, and the company is claiming the full JobKeeper payments. Should the employee receive the full gross wages, and is this okay?
They're not really related matters, if I can put it that way. I'm assuming that the full-time employee again has, in an entirely open and legal way, consented to a pay cut. There's a lot of talk out there in the community about people taking pay cuts. You cannot make somebody take a pay cut. If somebody has willingly consented to taking a pay cut, might have been some level of encouragement in them doing that, that's fine, but that's an entirely separate matter. Unless, of course, you said, look, please take the pay cut of 15%. However, if I get JobKeeper, then I will reverse it. Well, then those would be the terms of the agreement. But assuming that the pay cut is properly, validly agreed to, that's an entirely separate matter to JobKeeper.
Yeah, and the only other thing I wonder whether what this is talking about is not a pay cut, but maybe if you're talking about a reduction in hours, if someone's asked to reduce their hours by 15%, then the answer is, and well, obviously what will come with that is a 15% reduction in your rate of pay, and the company is allowed to do that if they're participating in JobKeeper. And yes, they can still claim the full amount of JobKeeper subsidy from the government. So that's the point of the JobKeeper amendments, is to enable employers to lawfully reduce someone's hours. But that's not then a pay cut, that's a reduction in hours.
Yeah, and the only other thing I'd probably just add in, look, think about this from an HR perspective, from an employee engagement perspective. If you've had employees come to the table to help rescue your business with pay cuts, and then you become eligible for JobKeeper, I think you should be sitting down with them talking about what the balance of that is. And it might be, look, I can't give you back everything you cut, but I could give you back a portion of it. Because when you get out of this, you'll want those people working with you and helping you rebuild your business. So there is that engagement side to this question as well. It's a good question.
What advice can you provide to award-free employers in understanding the new JobKeeper powers? I'm happy to dive in.
Have a crack.
Look, it's an interesting question. In terms of the new JobKeeper amendments, there is no distinction between award-covered and award-free.
Or enterprise agreement.
Or enterprise agreement covered. The JobKeeper amendments prevail over all enterprise agreements, awards and contracts of employment. So an employer can exercise their rights under the new JobKeeper Fair Work amendments, and it will override any existing provisions. The only difference really between award-free and award-covered is this. If you have someone who is award-covered and you change their days or their hours of work, particularly if you move their day from a Friday to a weekend, or you move their hours from normal office hours to late at night or something like that, just be conscious that there might be award penalties at those new hours that you didn't previously have, and they still apply. So whilst JobKeeper enables you to shift someone's hours unilaterally if you meet the test, if the award now says, oh, you've got to pay a Sunday penalty rate because you've moved them to a Sunday, there's no exemption from that. So just be aware of that. But otherwise, everything that we talk about to do with JobKeeper applies equally across the board.
Yeah, and so have a good look at it, see how you can use it, just like every other employer's doing at the moment.
What options would a business have if a regular and systematic casual receiving JobKeeper is refusing to work additional shifts or even their ordinary shifts?
I think we've answered this, but just 30 seconds.
Yeah, so the short answer is you still need to pay them JobKeeper for as long as they are an eligible employee and on your books. But what the difference is that if they are continually not working their ordinary shifts, then at some point you're probably going to have a discussion about whether they're still needed for the business, and you might have a bit of a look at whether their engagement should be ceased. Probably different about working additional shifts. I mean, if you've still got a need for them to work their ordinary shifts and they start refusing additional shifts, I would start to ask the question as to whether that's a valid basis to dismiss. And remember, all of these casuals will have access to unfair dismissal laws because they're regular and systematic casuals.
Yeah. Look, can I just say to the audience, we're getting a tremendous amount of questions through. Questions that are kind of like one short, quick grab are going to get on. We've got some questions coming through that are like half a page. I've got to be honest with you, we're not going to get to those today, okay? So just think about how quickly can you digest the question to a point where we can stick it on the slide.
Can we request a casual to work the same hours as before when they are eligible for JobKeeper, and can I deny JobKeeper if they refuse to work the same hours?
It's almost the same question, but look, so for the first part of the question, the answer is absolutely. In relation to the second part of the question, it's not that you can refuse them JobKeeper, it's you've got to just do exactly what Lewis has been saying. You've got to go through a normal investigation and disciplinary process as to why the person's refusing the shifts. I have heard a few younger casuals say, I'm going to stay home and surf and get the $750. I'm sorry about that. You're just going to have to deal with that head on, just like you would any other time when your casual says, I'm not coming to work today, I'm not doing that shift, I'm not doing next week's shift. It's business as usual, unfortunately, and I'm sorry that some people might be cynical like that.
Can we put employees into negative leave balances for fairness and equity to those who still have balances that they have to reduce during the JobKeeper payments? That's an interesting question. The reality is, if we're talking about reducing people's leave balances, I think the question is assuming that someone's exercising some right under the JobKeeper legislation or under award to direct people to take annual leave.
Or under the Fair Work Act for award-free employees.
Yes, or under the Fair Work Act for award-free, that's right. So let's say that the employer has done that and they have directed someone to take leave. You can obviously do that for people with leave. If someone runs out of leave, your very first question is, do I have a right to actually direct someone to take unpaid leave or to go into leave in arrears, effectively? Now, the first part of the question, do I have a right to direct someone to take unpaid leave? Well, often you don't, but that's the JobKeeper amendments do allow you to do that because they allow you to reduce their hours to zero. But that doesn't involve taking down or drawing down from their leave balances. The JobKeeper direction is to simply direct someone to reduce their hours to zero, not to go into unpaid leave. If you're using some other power to get someone to go into arrears, you really need to find a source for that entitlement, because there is no source of entitlement at large in the Fair Work Act that says you can force someone into a negative leave position.
So leave in advance as a concept is available, but in all the awards I know, Lewis, it's always by agreement.
Yeah, and in the award safety net, it contemplates it. Now, employers have been doing it for a long time before it came into the award safety net, but it was always done by agreement. Generally speaking, there is no provision in either the Act, the awards or contracts that we tend to see that enables you to actually direct someone to go into arrears, and indeed it's probably inconsistent with the NES. So if you're going to do that, you need agreement.
So I think, just to sum up, if you've got people who are taking leave to help you out, you've got people you want to take leave in advance to also balance that out, you can make that request, but you can't put those people in balance. In other words, you can't direct them or force them to do that. You're going to have to get their agreement to do that. They might be willing to do it, which is great. They might not be. If they're not willing to do it, you can't force them.
What does termination entail for a casual? If a business closes and there is no work for casuals, are they terminated at that point, such that employers would need to elect to include them in JobKeeper? It's neat. The first part of the question is very interesting. What does termination entail? And it's actually a fascinating question, entirely separate from the whole COVID-19 dilemma, because the Fair Work Act talks about the fact that a regular and systematic casual who's been working for you for at least 6 months with an ongoing expectation of ongoing shifts on a regular and systematic basis has access to unfair dismissal laws. But by the same token, or equally at the same time, what we're told by the law generally, and this has been reinforced by the recent Federal Court WorkPact decision, is that a casual employee's employment actually starts and finishes at the end of each engagement. And the question then becomes, well, if that's the case, how do we know when work starts to tail off, how do we know when that work has sufficiently tailed off that there's actually been a separation of the relationship? For some casuals, they might just slowly just disappear into the horizon, and one day you wake up and think, oh, we haven't seen them for 3 or 4 or 5 months. I suppose they're not really employed anymore. And sometimes they can just kind of slowly vanish into the air. The Fair Work Act doesn't really contemplate that because they have unfair dismissal provisions. So at some point, there must be such a reduction in their hours that it's what the Fair Work Act considers to be a termination. And what I would use as a appropriate yardstick for that is, if you have an employee who has a regular and systematic load, they might work 15 hours a week. Yes, sometimes it's 13, sometimes it's 18, but they have a general load that they work week in, week out. If you unilaterally reduce that effectively to 0 or to something close to 0, 1 or 2 hours, that's when you start to get into what we call a constructive dismissal under the Fair Work Act provisions, and the casual can say, well, actually, I think you've actually ended the relationship. But there's no one answer to that question.
And what I'm actually practically seeing at the moment, thinking about the employer my son works for, he's a university student. His employers basically said, look, can't keep all the coffee shops open, can't keep all of you working at the moment, but you're all on the books. I'll keep you on the books. As soon as we get going again, we'll work out who's going to get what shifts. So in that sense, it's very clear that nobody's employment's ended as such. That'd be very different to simply my son being said, mate, look, I'm taking everybody off the books. I'll worry about who I employ when I come back. That's the sort of what I call common and garden language that a lot of employers, particularly say the coffee shop owner, is going to use to demark what we might describe as putting you on hold versus actually saying our relationship's come to an end.
But for someone who's I agree entirely, and I think the real challenge is for those of you who are out there, and I know there's a lot that have casuals working 38 hours a week, week in, week out for a number of years, do not think you can just reduce them to 0 and say, oh no, that's not a termination. Oh, you're still on the book. At some point, if there is a significant reduction, you're going to have a problem from an unfair dismissal point of view. And that's why you might be looking to use your JobKeeper directions. That's the very point of JobKeeper, is to enable you to do these things lawfully without being exposed to dismissal claims. So if you're in that book or in that basket, what I'd recommend is get them validly signed up to JobKeeper, and then you can lawfully reduce their hours to 0, and there will be no question about whether
the ambiguity is gone.
Correct.
The ambiguity is gone.
We have an employee we have asked to come back to work, which is in a warehouse, so cannot be worked from home. She is scared to be out in public due to the virus. How do we best manage this? I think that's a really interesting question, and one that we got a lot of really early on, so kind of early, mid-March, when people
we were
were
hammered by it, weren't we?
Yeah, when people were particularly concerned and not everyone had kind of ended up at home. You're first and foremost, your question is work safely able to be performed? Has the employer done all it reasonably can to minimise risks to health and safety in the workplace? That's step one. Let's say you've done that, and you've done all you can to practicably speaking, minimise all risks that are identifiable. At that point, you have met your obligations under health and safety laws. The employee has an obligation to present for work. Then the question arises is, well, is there a valid reason why the employee is unable to attend for work? If the employee is unfit to attend for work because of some medical condition affecting them, that means that the risk to them is so manifest that they're simply not able to work safely.
Public, even get to work.
To either get to work or to work safely, then they may be sick. Well, not sick, that's a poor expression, but basically they may be unable to attend or unfit because of a personal illness or injury affecting them. Your classic entitlement at that point is sick leave, is personal leave. If, however, they are an employee that's in no different circumstance to most other employees and they do not want to present for work because of fears or anxieties they hold, they might not be unfit for work. And so then you have a scenario where the employee is simply not wanting to turn up. Now, the first thing you might do is see whether you can accommodate that. So you might say, well, look, why don't you use your annual leave, or why don't we...
Well, it's hard to accommodate. We're in a warehouse. You're right. You'd have to put them on leave.
On annual leave, or you might say to them, do you want to take a period of unpaid leave? If you're unwilling to accommodate that, then you get into a more robust discussion about, well, can they do the requirements of their role? Is this a disciplinary issue? You're going to have to step very softly and carefully around this issue, because obviously we're in a very unique scenario. But if it can't be accommodated through leave, they're in no different category to anyone else. You've done all you can to minimise risk to health and safety. You're getting to the point that you might have a discussion about whether they can do the role or whether they need to be warned about absenteeism, so on and so forth.
And look, you'd really have to look at the facts of the case. We'd have to be very careful how we work our way through the facts. So that's a great general answer, but it'll be very fact specific, so just be very conscious of that.
How do we treat staff who are choosing not to attend work, i.e. they have not been stood down, but are otherwise eligible for JobKeeper payment? I think that's a combination of the two that we've just answered.
I think we're comfortable with that. Yeah, I think we'll be comfortable with that.
What capacity do we have to direct staff to work either above their normal hours, if required, or preventing people from taking excessive time off and still receiving JobKeeper guaranteed payment? Interestingly, with the first question, direct staff to work either above their normal hours if required, I think we did answer that early on. And
you've got to find some power that says you have a right to be able to direct that. That there might be, for some part-time employees under some modern awards, there might be a right to direct some level of additional hours. I've seen some enterprise agreements that say I can direct some additional hours. I've seen employment contracts for non-award people that say, particularly for part-time employees, I could direct some additional hours. You've got reasonable requests in terms of overtime, but I suspect this isn't about overtime. I suspect this is about what might otherwise be described as ordinary hours of work. So I think we've answered that already.
And the second one as well, I think taking excessive time off. Again, if it's the casuals, we've talked about that concern. You might keep offering shifts for a while. If it's until such point as it becomes apparent they're just not able to do your hours anymore. If it's a permanent staff member, it's different. You're going to be looking into, well, why are they taking time off? Are there illness or injury issues? If their absenteeism is not justifiable, if there is no reasonable basis, we start getting into the usual discussions you have around that.
All the normal rules would apply. Are they on paid personal leave? What's the period of absence? What's the reason? So again, we'd have to look at the facts, but all the normal rules would apply. JobKeeper doesn't change that.
Are employers that are not currently eligible for JobKeeper payments still enabled to utilise the COVID-19 pandemic special provisions that are specific to each award?
Absolutely. Yes, the answer is yes. Categorically, you can use what's in the award. You can use what's in the Fair Work Act. Again, think about the smorgasbord. I might not be able to use those JobKeeper directions if I don't have JobKeeper, but I've got the modern award stuff and I've got the Fair Work Act stuff.
Yep.
I think we've answered that. That was good. It's good. So I cut you off. You didn't
No, that was just... Can an employee change which employer pays them JobKeeper throughout the program? Who's taking this one?
I'll take this question. I suspect, this is going to be pretty rare, I suspect, because let me just start with two potential scenarios. Scenario one is, which I think would be strange, but I'm currently employed by you and I get a better job offer tomorrow, bizarrely, and I come and work for me, in that situation, I couldn't get JobKeeper for you because you weren't working with me on the 1st of March.
Yeah.
So if you're thinking about jumping ship on that basis, think very carefully. So in that sense, the answer would be no. If you want JobKeeper, it's with the 1st of March employer. It's not with a new employer. It might be a different question, though, because it might be the question about, say, the pub, and I've got 3 places I work. What happens if I select, first of all, to be with employer 1? Let's say I fall out with employer 1. Can I then go to employer 2 and 3? Look, I don't know the answer to that question. I don't know if you do. I haven't seen it.
No, I think the reality is that the primary threshold test is to be employed on 1 March, so you will have ticked that box, and employees do get the opportunity to nominate whether they want to participate, and I've not seen any time frame on nominating.
There's no you must in 14 days or anything like that. There's nothing I've seen in the statute that says once signed up, that's it, you're done.
That's right.
I suspect you could do it, but I think the answer is if that's a very real issue, give us a call, I'd say.
Yeah. Can an employee volunteer to stand down so they can receive the JobKeeper payment without using any personal leave, annual leave or long service leave? It's an interesting question because an employee...
Perhaps I can ask this way. We might cut this one a little shorter. You don't as such volunteer to stand down. You could agree to take leave without pay. And that's possibly what the question is asking. So, Lewis could agree to say, I agree to take a month's leave without pay, and during that period, I'm going to pay Lewis the JobKeeper payment. That's acceptable, isn't it?
Yes.
Yeah. The alternative could be, I get the JobKeeper payment, and then I give you a stand-down direction, and then you're stood down during that period, and I pay you the JobKeeper payment or the value of it, the $1,500. Is that the best way to answer that?
Yeah, I think so. And really, most people who are seeing their hours reduced in the JobKeeper context will probably be a direction by the employer to reduce hours or to go on leave or some other combination of the two. So it's unusual that the employee would do that, but at the end of the day, it really would need to be by agreement. If the employer's still got work, then you can still be required to work.
Yeah. I think that's the other thing that's just really important about this is that if you're getting JobKeeper, to the extent that you can use your people, I'd really encourage you to use your people. Don't let any work that could productively be done. I mean, if the answer is, look, I've got that project I want finished off for next month, my alternatives are bring Lewis in and get him to help me on it, or let him sit at home and get his $750. Well, see if you can bring him in and get him to help you with it, subject to all the things we've talked about today in terms of getting him to come to work.
Yeah. What happens if a casual hasn't worked with any regularity over the past 12 months? 1 day, then 2 months, later 3 days? Well, the short answer is they're not going to qualify.
They're not going to qualify. You've got to be 12-month period. You've got to be regular and systematic. If you are over 12 months but you are irregular and not systematic, then you're not qualifying.
Yep. If registered for JobKeeper but with no annual leave or sick leave balance, employee calls in sick, still required to pay the $1,500 per fortnight? Short answer is yes. Assuming they're an eligible employee, if they run out of leave but are sick, you still have an obligation to pay them $1,500 a fortnight. You're going to come back to some considerations though. If this happens for a day or a few days, that's probably not an issue. If you have an employee who calls in sick for a month because of some condition, you technically have an obligation to pay them JobKeeper, and you still need to be very careful about trying to discipline or otherwise address that matter because you have discrimination laws that apply, you have adverse action laws that apply, you have protections on terminating people for temporary absences or illnesses. So the very fact that someone's sick, even if they don't have a leave balance, they can still say, well, I'm not fit to come in. And there's a lot of protections in place in both Fair Work and discrimination legislation that prevent you from simply just acting in a disciplinary sense immediately.
Let's jump in and ask the sticky question. It's not this question, but let's just quickly deal with it very fast. If I'm stood down, can I claim sick leave?
Well, that's a different question. And there's 2 types of stand down that we're talking about.
It's the ACT stand down, enterprise agreement stand down, contract stand down, then there's JobKeeper.
Correct. And so with the stand down provisions of the Fair Work Act, this is an issue that is hotly in dispute
It's in
right
federal
now.
court right now. Justice Flick's reserved on it with Qantas.
That's right.
Yeah.
So there are arguments both ways as to whether or not you can apply for and take sick leave while stood down, and we're awaiting a decision on that. So the short answer in that is there'll be definitive guidance from the federal court very soon. The unions are saying you can, Qantas is saying you can't. We've actually provided employers with advice on this, and it is quite line ball. The second type of scenario is if they're on a JobKeeper stand down. It's a slightly different scenario because in those circumstances, an employer can actually reduce someone's ordinary hours down to zero. So if you're reducing an employee's hours down effectively to zero, the notion that someone could then apply for sick leave is probably less available. But again, I'd be waiting the outcome of the federal court decision, which we understand to be not far away.
I think the judge said 10 days.
Oh, well, there you
10
go.
days. I read this morning. Said 10. I'm just going to. Can I intervene for a second?
Yes.
We're getting a lot of questions on the feed, which one of them hasn't come up yet. That is, what if, and this is a version of it, what if the employee is eligible but doesn't consent to JobKeeper? How does one and all in work? Your obligation is to ensure that you provide the opportunity to the employee. The legislation doesn't even use words like reasonable or whatever, just provide. If the employee actively declines, says, I don't want JobKeeper, that's their decision. If they ultimately don't fill it out, that's their problem. Obviously, most employers will probably be encouraging their people to fill it out. Your obligation is to provide the form, the opportunity to them to do that.
Yeah, and they only become entitled to the payment once they give it back to you. So if they haven't given it back, you don't claim JobKeeper for them.
Yeah, that's only the obligation in terms of one and all in, is the provision, the invitation, as it were, to participate.
Uncontactable staff members. We have work for them to complete, but they won't respond to phone, email and text.
Oh, you can do this in 20 seconds.
It's the same as the answers we've given before. The only addition that I would add is if they are completely uncontactable. So what we've talked about
reasonable efforts to find them.
That's right. If they're completely uncontactable and you've exhausted all reasonable efforts to try and find out what happened to them, at some point that the very often misapplied notion of abandonment employment might come in, and you might be talking about whether they've actually abandoned their employment, or you might be talking about disciplinary processes. So the usual considerations that would apply in that circumstance before JobKeeper apply now to that type of scenario.
So phone, email, text, if they're a long-standing employee, registered letter to their address, and if you're really, really long-standing employee, probably go and knock on their door.
And you should have alternative contact details as well. Do you know where their family are, things like that. But the biggest issue with abandonment of employment is that for some reason, employers think that the moment 3 days have elapsed, you can just say someone has abandoned and terminate on that basis. It is not that straightforward. It is not that easy. You need to make considerable steps
to be fair, Lewis,
by yourself.
60 years ago, that was the law.
It hasn't been for a long time.
It hasn't been for a long time.
So, and you just need to be very careful about that before you take the ultimate step. And the reason for that is if you are trigger happy and premature, you might find an unfair dismissal claim coming to your doorstep.
Yeah.
Is an employee who is not unwell but self-isolating based on government guidelines or medical advice eligible for personal leave? If they were asked instead by their employer to not come to work, what type of payment and leave should apply?
So let me take the first part and I'll let Lewis take the second part. So the bottom line is that in terms of accessing personal leave, you actually need to be ill or injured. Self-isolation doesn't get you over the line to claim personal leave. Just be mindful, if you're covered by a modern award, there is an ability to access unpaid special sort of self-isolation pandemic leave. You need to give us a call about that if you're not familiar with that, because that's really important. And also, if you're in the health sector, broadly speaking, and I mean very broadly speaking, just be aware there's actually a claim on at the moment before the Fair Work Commission for additional paid leave for self-isolation. Nurses, doctors, home care workers, aged care workers, a number of others. We're dealing with that as best as we can at the moment. That'll probably take 10, 11, 12 weeks to sort itself out. Second part of the question.
So second part, if you have decided to tell the employee not to come to work, that's a different matter. There are two questions that would arise. The first is, do you have reasonable grounds that are objectively provable to show they're not fit for work. So, for instance, if you know they've tested positive, or if there is some circumstance you can point to that demonstrates quite clearly they're unfit, then, and probably you'd want medical evidence of some kind to support this, then you could direct them to stay away on the basis they're unfit and direct them to take personal leave. Absent that circumstance arising, if you are directing them to stay away and you have no clear evidence that they are unfit, you would need to pay them their wages. So you can ask people to stay away, but you need to ensure that you're paying their normal wages during the period.
So go to our website. I think we've got a big resource catalogue. I think you'll probably want our very first Q&A. It deals with a lot of this, and that's about whether or not, for instance, if somebody about 4 weeks ago was coming off an aeroplane from, say, Italy, are you entitled to say, go self-isolate, I'm not having you at work, and you don't have to pay them? The answer was yes, we don't believe you have to pay them. So go back and have a look at some of our resources because they'll answer those questions in a great deal of detail. Mate, we've got 4 minutes left. I don't know how many we've got through, I'm not sure.
If an employee refuses direction to take annual leave where they will have a balance of 2 weeks, will this then be a disciplinary situation if they can't come to an agreement if they flatly refuse? Now, I think it's interesting because if the direction's been issued validly, a direction's been issued under a modern award or the Fair Work Act, it actually does need to be complied with. And if they refuse, there's really 2 courses of action open to an employer. The first, ordinarily, we would see is, well, the employer will simply implement the direction and they will say, well, you're on leave, I don't need you to come in, employer probably won't come in, and at that point, the employer would simply just start deducting from the leave accrual, and that will be permitted because it will either be permitted by the modern award or will be permitted by the Fair Work Act or the JobKeeper amendments. The other scenario, which is probably unlikely to arise and be more curious and odd, is the employee doesn't agree and still just starts fronting up to work. Well, at that point, they're really misbehaving. They've been issued a direction, provided it's lawfully issued, you'd be starting a disciplinary discussion.
Yeah, I'm cool with that.
Are employees on unpaid parental leave entitled to the JobKeeper payment? If you don't have an employee nominated and being paid in April, as they are on unpaid stand down, can you start paying them and claim for May onwards? I think we've dealt with the first part of the question in some detail. And the second part is, yes, if someone isn't eligible initially, they can become eligible later on in terms of, sorry, I should rephrase that. If they're not entitled to JobKeeper payments initially, but later become so entitled, as long as you've qualified for the scheme, it does appear that they can receive the payments later.
Yeah, and I suspect the truth is that as long as you were employed as of 1 March, it's quite possible that an employer might be faster or slower in actually accessing JobKeeper. Some people might not get it till May, some people might not get it till June. It might be that the employer doesn't meet the 30% hurdle till June and then only applies from June. So, a good answer.
How to handle staff refusing a reasonable, lawful, safe, related to the business, JobKeeper enabling direction, i.e. they're just not turning up to work.
Well, just before I think we've answered this in many ways, but also just to remember in relation to JobKeeper directions, formal ones, the JobKeeper legislation expressly requires compliance with a JobKeeper direction. So in terms of adopting what we might describe as normal performance management to this, it's actually bolstered by the fact there's an express obligation to comply with a JobKeeper direction. But it will be the normal performance management process.
If we have reduced eligible staff hours from normal 38 to 30 hours per week, do we need to go back to 38 hours pay just because we're getting the JobKeeper payment? I think Nigel answered a question of this nature earlier in the webcast. If you've reduced their hours lawfully and legitimately, and that agreement was for a period or is indefinite, well, then you can rely on that variation to say, well, no, now your hours are 30 per week. And the arrival of JobKeeper would not change that. If your arrangement isn't so legitimate, then you probably want to re-look at it and redo it properly under the JobKeeper.
Yeah, and as we said before, in terms of employee engagement and people helping you out, if all of a sudden you've got the benefit of JobKeeper, it wouldn't hurt to sit down and say, look, let's review where we are now. Can I actually give you a little bit more back rather than thanks for everything you've given me, I'm now looking a lot better because of JobKeeper. So there's that HR element to it as well. Look, that's our hour up. It felt like speed dating. Not that I've ever been on a speed date, but it felt like speed dating. Can I say a couple of things very quickly? If anybody wants us to have another go at this, please let us know because we'll actually organise another one. We got a lot of questions I think we didn't get to today, but we'll do our best. Number two, we had a lot of requests for can you let us have a letter to give our employees. We'll organise to have a giveaway, which is a letter. Here's all the questions that we've missed. Here we go.
Moving to the last slide.
She's very, very helpful here.
There you go.
So people said, can you give us a letter to actually send to our employees, inviting them to participate with the form they had to fill out? We'll actually give you one of those today. I'll talk to Fiona Kenny about how we organise that for you. But look, thanks for coming on. Thanks for helping out with some pretty good questions, some pretty challenging questions. I'm sure there's a lot more. I imagine we could be here for another hour. But if you want us to be here again, let us know. Lewis, thanks very much. It was fun.
Thanks for having me.
And look, please, everybody, again, please take care. Please stay well. And if you do need to give us a call, you want some more detailed advice about your specific situation, as always, let us know and we'll help you out. Take care, everybody. Thanks very much.